Hello, everybody. Welcome to The Productive Attorney, the podcast where we teach you how to be more productive as an attorney so that you have more time to do the things that you want to do outside of law. Today, we're going to be talking about reputation and what your reputation is as a lawyer. Starting with the big picture, if you research lawyers' reputations and you try and find out, what we were looked at from society, most people don't think we do much to help society, and that's why there's lawyer jokes and other comments about lawyers. But we are held in high regard by societies general and people generally. Our reputation is one of being smart, of making money, of having power and influence, and we are, as a profession, generally well respected. If you look at doctors, 92% of women said they would date a doctor. 89% of women said they'd date a lawyer. Those are the two highest in the surveys of people that are somebody that looks like they're stable and that someone would want to go out with. There's a saying that everyone hates their lawyer except their own lawyer. And so we've got this reputation generally as attorneys, and I don't think there's anything that we do as attorneys other than if you get involved in community education and other issues that we can do to change the overall picture of the reputation of lawyers, except by working one person at a time and one client at a time by doing the right thing all the time. And so I don't know that there's much I can talk about on the big picture on what society feels like we are as lawyers, but I can talk about our reputation as attorneys within our own profession and among our coworkers and among judges and staff, and what our reputations can be and what you can do to increase those reputations, or what you can do to mess up your reputation. I started practicing law 34 years ago this year. And when I started practicing law, there was an agreement that you would make with an attorney on the other side. You would pick up the phone and you say, hey, Mr. and Mrs. Attorney on the other side, we've got discovery due next week. Do you mind giving us a 2-week extension? And the other attorney would say, no problem, 2-week extension. And that was it. There was no confirmation letter because, we just had started emails back then. There was no confirmation email, no confirmation letter, no nothing. It was just you called up that person and you told them it was 2 weeks and they said 2 weeks and that was it. And with that kind of way of doing business back in the day, if you screwed someone on that and you went back on that 2-week extension, you were done. Most, 34 years ago, there were a lot less attorneys in every city and every town. And if you went ahead and reneged on one of those agreements, you couldn't really do business in that town. You got a reputation as somebody who you can't deal with that lawyer. That lawyer won't deal right. And that's the last thing you wanted, was that. And I remember vividly, there was a change in the Texas Rules of Civil Procedure called Rule 11, in which an agreement is only binding between attorneys if it's in writing, signed by both counsel, and filed of record. That's since been changed where you can have an email exchange, and that can be a Rule 11. But back then, it was a written agreement. And a baby lawyer called me. I said baby lawyer. I was like a 7-year lawyer, and this was like a first or second-year associate. And he called me up and he said, Jim, can we have 2 weeks on discovery? And I said, of course you can have 2 weeks on discovery. We have an agreement. And he said, okay, I'll send over a letter and you sign off on it. And I said, young man, you need to understand that my word is my bond and that you don't need to send a letter. And he said, well, there's this new Rule 11. And back then, we didn't have the internet. We didn't have information about rule changes until we kind of got a briefing as a firm or briefing as a group. And I'd only heard a little bit about Rule 11 changing, but not enough to know, like a new law student coming out of school, that they needed to be in writing. I felt really bad that I acted all hoity-toity when in fact that person had the law correct. Part of the reason why the law changed back then to now, a lot of the changes had to do with Rambo litigation. And that's the litigation where the attorneys would come in and they would just do scorched earth. Um, there was there was a lawyer who became a federal judge whose reputation was one of just destroying the other side with scorched earth. As an example, before the rules changed, federal rules are 7 hours for a deposition and state rules are 6 hours. There was no time limit on a deposition. And this lawyer had a reputation of sending discovery with his answer, not giving any extensions, asking for immediate deposition of the plaintiff, and taking several days for a plaintiff's deposition that just went on and on and on, just as a scorched earth way to just wear the plaintiff's attorney out. And that individual got a reputation of being the one that was the most difficult to deal with. And when he became a federal judge, he was highly aware and would not tolerate the conduct that he was doing when he was an attorney, because he thought that everybody was trying to do the same thing that he was trying to do. There was other types of Rambo litigation back then, but mainly what it was is just lawyers not really staying with their word, going forward with litigation or going forward as an attorney with just methods that were designed to make it as difficult as possible on the other side, and at the same time, no real benefit to pushing the case forward. All it is just like, if you get this person on their side, it's going to be terrible. And so in Texas at least, we have a decision called Dondi. It's a federal court decision that really sets out kind of a lot of the ethical parameters. We have the lawyer's creed. Obviously, we have the disciplinary rules, and we have changes in the Texas Rules of Civil Procedure. And if you're in federal court, you have changes in the Federal Rules of Civil Procedure. And those were all designed to take the Rambo out of the litigation, to make things a little bit better. But even still now, with those kind of rules in place, you still run into attorneys who want to make the litigation more painful for the other side and use tactics to do so. Multiple motions, lots of discovery, unnecessary depositions, which are allowed under the rules, but really they don't advance the litigation in any way. And so you can get a reputation, male or female, get a reputation as being somebody who's very difficult to deal with. And I personally don't think that's a great reputation to have. I have asked many attorneys and many insurance adjusters, hey, do you pay more for these people that are jerks? And they all say to a person, no. And in fact, when we have an opportunity to not help that person with a settlement in a case on the plaintiff side, or on the defense side, not settle the case and make it as difficult for that defense attorney with their client, they say they'll do that because that person has been so difficult to them. And I've always, been of the saying, you catch more flies with honey than with vinegar. And that saying kind of rings true with respect to you're nice to the other side, but at the same time, you zealously represent your client and you research everything and do everything to the fullest extent that you can by the law. And so my philosophy is always being able, as my reputation, is that when I go to bed at night, I want to know that when I wake up the next morning, because of my pattern and practice of how I do things, I know that I'm going to do the same thing and the right thing 100 out of 100 times. And so I go to bed and sleep soundly because I know I've given extensions when extensions need to be given. When I see an extension is being done for a tactical purpose, instead of going right out and attacking somebody and saying, hey, you want this extension or this kind of issue in this particular case that I believe is an advantage, I will ask them why they need it. I usually give these, but this is kind of putting me in a tough spot. Here's why it's put me in a tough spot. And so I just want to make sure that we're on the same page. I need some concession from you to get me out of this tough spot in order to give you what you want. Most of the time it is altruistic on their part. They aren't trying to get an advantage. They just didn't realize the impact that would have on me. But occasionally that fleshes it out or smokes it out. And in which case, I don't, we don't give the extension or we don't give the accommodation in that particular case. the other thing that I don't like, and I don't like attorneys to do, and you get a bad reputation for this, is when you hide behind this saying, well, my client wants to do this. So you do something really bad. I had a motion for sanctions filed against me in a case that I didn't need to have the motion sanctions for. I have not been sanctioned in 34 years of practicing law. And these people filed a motion for sanctions against me, and I didn't do anything wrong in the case. And they were trying to set it up, and I finally said to them before the hearing, I said, why are you going through with this? Doesn't make any sense. They said, oh, well, our client feels like there's a point to be made here. And I said, you're spending a lot of your client's money to do this motion that I don't think is going to work for you. And you're the attorney, and you're the legal expert. And if you think that it's wrong, you should let them know that it's wrong and stop it. But the partner in that particular case had a reputation, and we're back to reputation, of being somebody who will go after people. And so you just had to know that going in, and the way the story ended was the judge said, I don't know what else you expected Mr. Zeta to do in this case. He did things properly. I'm going to deny the motion for sanctions. But it wasn't fun, and it wasn't fun to deal with that person. And later in that case, they asked me for some things. Believe it or not, they had the gall to say, hey, is there some information we're needing? I'm like, hell no, I'm not going to give you that information. You know, you've got a reputation now of being very, very difficult, and I'm not going to cooperate with you. And that's just the way it goes. You know, I talked to a judge yesterday at a function, and we talked about how if a lawyer lies to a judge, that reputation of being a lawyer that is not candid with the court spreads through the courthouse. And people know that a particular lawyer has just flat out lied to a judge. You have to be transparent with the court. And if you've messed up, you need to come in front of the court and say, I've messed up, Your Honor. Yeah, I messed up. This didn't go well. I'm sorry. I apologize. What can I do to make this right? I had a recent case where I was counsel of record, and in the case, I got a phone call, and they said, hey, you've got a hearing right now, a Zoom hearing going on with the judge in a case. And I said, well, what case is it? And they didn't even tell me the case. And so finally I got with the court coordinator, and I said, just before you put me on with the judge, can you at least tell me the case name? And she told me the name, and I realized that my co-counsel, another attorney, another firm, was handling it primarily, and I was just secondary on the pleadings. But that co-counsel was unavailable. And so the judge, who I knew, was calling me. And so at this point, I had a general idea what was going on in the case, but not a lot of knowledge. But I knew the judge, and I thought, you know what? I'm going to come in and be right up front and transparent with the judge. And so I got called in, and it was a Zoom hearing, but I only got patched in via telephone. So I had the added disadvantage of not being able to see the judge's face and expressions or see opposing counsel's faces and expressions. It was one of the times when I got caught totally off guard, and I had no visual feedback to help me out. And so the judge said, we're here on a motion to compel by the other side. They want to compel some discovery responses, and they want to compel your client's deposition. And it looks like that you haven't filed a response. And so here I am in a hearing with no information and not having filed a response. And I said, Your Honor, I need to be perfectly honest with you. Co-counsel's handling this case. I have really not that much knowledge of what's going on, but I'm here for opposing counsel, and I'm here for the court to see if we can work something out. And the judge said, okay, there's two issues. Let's talk about the discovery. And they said that that we had waived our objections. And I said, Judge, what I can see on my online here is that we filed objections, but there are some answers that we had that they aren't satisfied with. And the judge said, is that correct? And the other side said, yes, they timely filed their objections, but they're not answers that are fully answered. And she said, well, I don't have time to go over all the objections on each particular question, but if he's gone ahead and answered these, he hasn't waived his objections. But I will tell you what, Mr. Zeta, will you how much time do you need in order to supplement this discovery? 30 days, Your Honor. And she said, oh, I've seen them shaking their heads. They want it in 14 days. And I said, Your Honor, I honestly don't know what it is. I don't know how much it is. If you would please give me the courtesy of 30 days, I will figure it out. Once this hearing's done, I will figure it out. And she said, okay, I'll give 30 days. And the second one was, when can you get your client for deposition? I said, same problem, Your Honor. I don't know this case that well, but I will guarantee the court and opposing counsel that we will make the plaintiff available for deposition in 60 days. They wanted it shorter, but the judge said, no problem, you can get it in 60 days. And that was it. And the hearing was handled, and it was done. And we were able to get the stuff that they wanted in 30 days, and we were able to get the deposition in 60 days. But that's a situation where you go in and you just come in, try and help. And at the end of the day, opposing counsel and the court realized that I wasn't trying to do anything crazy. I wasn't trying to hide anything. I was really trying to help everybody get to the end of the situation. It was tough. It's tough walking into a hearing or going into a hearing in that situation. I do want to tell another war story. This happened when I was an attorney for about 10 or 11 years. And I had a plaintiff's case, and the case kind of went south. It wasn't going very well. And the other side had a motion for summary judgment. And it was a young attorney, and she was very aggressive throughout the case. But she seemed like relatively was nice at times, and then kind of turned not nice at other times. I couldn't really get a handle on her, but since I had such a bad case, I didn't know, I wasn't able to press anything or press any advantages. And so they filed a motion for summary judgment, and the judge heard the motion for summary judgment. And he said, Counselor, you all need to go back in the jury room and talk about this case before I rule. That was judge code to me, that he was about to grant the summary judgment and that I need to take whatever's on the table, which I had authority from the client to do, which was to take, if they made an offer, to take an offer, because we realized that the case had gone south in the development of the facts. And so the second we got in that jury room, that young lawyer called me a liar. And it wasn't in such, it was a very strongly worded accusatory, you just lied in front of the judge. And I said, wait a minute, I did not. My reputation is very important to me. I did not lie in front of the judge. I don't know what you're talking about. He just brought us back here to talk about trying to get this resolved, and I would like to try and get this resolved. And she kept on saying, no, you lied, and you have to go in front of that judge and tell that judge you lied. I said, I did not. I did not. And she said, well, there's a deposition part right there where your client said this. And I said, you were in the deposition. You know you can't see tone. That you know how this all played. You were there. And she kept on. And her partner was in the room. And what was really bizarre was he was wearing a golf shirt, and he kept trying to help the associate, like from behind the bar. He would come in front of the bar, point things out to her, and the judge got really upset with him, saying, she's capable, let her go ahead and make her argument. I didn't know who he was. I'd never met him. I thought he was the client or something. Turned out it was a partner. He came back in the room. So I said, well, look, I'm not going to sit here and be called a liar. I thought we could try and get this thing done, but I guess not. And we walked out, and I said to the judge, the judge said, how did it go, Mr. Zeta? And I said, well, Your Honor, the second we got back in the room, opposing counsel called me a liar. And he said, well, that's just lawyers being lawyers. And I said, Your Honor, she didn't stop. She called me a liar throughout our conversation. And she came at me and my reputation. And fortunately, I have a good reputation in the court, and I do in these courts around here. So we turned to opposing counsel, and he said, what did Mr. Zeta lie about? And she brought up the deposition part, and she said Mr. Zeta argued the opposite of what he said in his deposition. And I said, Your Honor, she was at the deposition, and she knew he was being sarcastic. And because I didn't say on the record it's sarcasm, but she was there and she knew it, and all the other facts show that he was just being sarcastic and was joking around. And he turned to her and said, "Counselor, you were there. Was he being sarcastic and joking around?" "Well, yes, Your Honor, he was." And he said, "You may not remember anything else about this hearing, but you do not come in front of the court and call someone a liar when you don't have the facts to call them a liar. You should never, ever, ever do that. And I'm going to deny your motion for summary judgment." 2 weeks later, she was fired from her job, and they called and we settled the case. And they made an offer, a fair offer, and we settled the case. That's a case of someone who went overboard and had mistakes in judgment and attacked someone's reputation wrongfully. The other thing that I see a lot in terms of reputation is I see lawyers calling other lawyers, attacking the other lawyers directly in briefing, in the way they write, and they really come at the other lawyers. And I will tell you that as an attorney, when I see the other side attacking me personally just because I'm representing this client, but making statements in there, statements that they think are cute, they're kind of edgy about how they attack you, just kind of implying it with big words and things like that. Judges hate that. They hate that. All they want is the facts. They don't care that you have a personal beef with the other attorney. And so you get a bad reputation if you start trying to knock down the other side in your briefing, and don't do it. Now, as opposed to when I started 34 years ago, there's a lot more information online about attorneys. And your online reputation more and more impacts what they think about you and what your reputation is. If you have just a social media page that is just, a placeholder web page for your law firm, that affects your reputation. People now, especially younger people, expect you to have a solid website. And if you don't, your reputation is weaker. And if you don't manage your online reputation, you don't manage all the reviews that are out there, you're going to start seeing that you get bad reviews, and you're not going to get calls because people are going online and they're seeing this bad stuff about you. So if you haven't gone online and started to manage your online reputation, you need to do it. And here's the way you do it. Number one, you got to identify it. Identify what your online reputation is. How do you do that? I go online and I look up Jim Zeta reviews, and I start looking at what's out there about me and what's being said. And I do it periodically, like once every month or 2 months, just to make sure that I'm up on everything. We have emails that come to us when there's a new review. We've got other things to check on it, but I also like to check regular. Then you can improve that reputation by asking for reviews. The third thing you can do is you can master social media. So by mastering, I don't mean get to understand the whole internet. I mean just the little part that applies to you and your firm and the reviews. And then if you really want to step it up, you can do some public relations work and get your reputation up. And there's several ways to do that. And then the last way is your website. And website you can make super strong by having great content, highlighting your positive reviews, get testimonials, get videos. You can just do all sorts of things to make your reputation better online. And the review sites that are the most important. Right now, Google is trying to take over the world, and one of the ways they're doing it is through reviews. And so you go out and get your Google reviews. Anytime you get a review, try and get it through Google. That to me is the strongest one. If you can get a Google review, that's great. Next, believe it or not, is Yelp. And I only have, less than 10 on Yelp. They're all 5-star, and that's nice to have. And every once in a while, I'll ask someone to give me a review on Yelp just so I keep that active. The third one is Avvo, AVVO. You have a reputation or an automatic rating on Avvo. It's usually in the 7s. They don't even know you, but that's what they start with. You can get that up to a 10 if you've been practicing for a while relatively easily, just by putting some time into it and working on it. And you want that. You want to have that 10.0 on Avvo. Martindale Hubbell has the AV and the BV and all that stuff. In the day, Martindale Hubble was the only service that gave reviews online or gave ratings. And so an AV rating was everything back then, and you'll still see it on websites, but it doesn't have as much pull as it used to. It's like behind Google, Yelp, and Avvo. Then you have lawyers.com, you have Better Business Bureau, and then Facebook has reviews, and you want to see if you can get your law firm webpage or law firm Facebook page, and then you want to get reviews. So I try to sprinkle around reviews to each one of those sites to make sure that I continue to have my reputation going on all of them. Another way to get your reputation up is public speaking, and that is just going out and talking to public and getting as many speaking engagements as you can get. I know that there's lawyers that do a lot of speaking engagements, and that really helps their reputation by doing that. Podcast, which I'm doing right now. It's always great to get out and put your views out there. I think being solid on a listserv in your community is a really good way to increase your reputation. Go into listservs and contribute. Give real solid information. A bad way to hurt your reputation is going on a listserv and giving poor content or poor information or poor feedback. So resist the temptation to respond to everything on the listserv. Only respond to the things that you know and that you think can help people, and do that. I'm on a major listserv, and there was a person who asked for some feedback on something, and I gave them it was on to the whole listserv, and I told them what I thought. And I got a private email from that individual who's one of the biggest contributors on the listserv, thanking me and saying my response was an excellent response. Now I've got the guy on the listserv who said that my response was really good, then my reputation with him, and therefore reputation through the listserv, is increased. But I don't try and multiply on that by talking about things that I don't know about or things that I only know a little bit about, and that doesn't really help people. In fact, makes you look kind of silly. And then the last thing I want to talk about is reputation outside of co-counsel, opposing counsel, and judges. And that is, you have a reputation with your employees and your staff or your paralegal or your legal assistant. And that reputation is different than your reputation as a lawyer. And that is how you treat that person, how you treat that staff. And I've talked about this before, but you've got to have your finger on the pulse of your staff. You've got to know what's going on and figure out what's going on in their life and help them, because you have the ability to help them, and they have the ability to make your life amazing, or they can make your life miserable. And so obviously you really want to be strong with your staff. Same with court staff. If you're a litigator and you call up the court staff, you need to be helpful to them. You need to be nice to them. You need to do everything you can to help them do their job and make their job easier. I've told this story before, but when my father passed away, there was a court coordinator where I happened to have 3 hearings in the 2 weeks after my father passed away. And I asked her for just an extra week, and she was so nice and said, "You're going to need more than a week." And all of a sudden I got orders on all 3 of those cases that the hearings were postponed for 60 days. And that court coordinator, she was right. She was a godsend. She was an angel. I needed every bit of those 60 days in order to be properly prepared to go ahead and represent my client in the proper way. You have reputation among clients, and then community and family. If you go out in the community and do something stupid, you've got cancel culture, and that cancel culture will catch up to you through social media, through everything, and you'll be down. You'll just be canceled if you do something really stupid. And so, don't be stupid. Say things. Don't say things crazy on social media. Certainly don't go on social media if you're impaired in any way, whether it be alcohol or drugs or anything, because you will say something that you won't be able to get back, and you won't be able to get your reputation back. There was a partner who said some things in an email to a opposing counsel when he had obviously been drinking, and got posted as part of a sanctions motion, and he wanted to fight it and eventually lost his job over it. You don't want to be that guy. You don't want to be stupid. So that's as much as I've got on Reputation. 30 minutes on Reputation. Hope you have a great week. Thanks.